Jack Reznicki and Ed Greenberg.
Thank you. Thank you for the introduction. As we said, this is a whole new program for us. A lot of the basic stuff of copyright, we'll be covering some of that, but a lot of it we covered in our last talk here, which is already on the B&H channel, and you can see us on there, or you can go to our blog. So these are our names. Ed Greenberg over there, he's the lawyer.
The good-looking one.
Right. And Jack Reznicki, I'm the photographer. Because last time we did this, people confused us. They thought I was the lawyer for some reason. We do have a blog where we talk about a lot of different issues and current events. And we talk until we're blue in the face about these things. And the blog is thecopyrightzone.com.
Not limited to copyright issues by any stretch.
All sorts of issues. If you follow our column in Photoshop User Magazine, you're familiar with the way we write. We write in plain English. We talk in plain English, especially about, I'm seeing a couple of people nodding their head. You've heard us before, and you showed up anyway. So, okay. If you do have any questions, these are our email addresses. Ed is ecglaw@gmail.com, and I'm jack@reznicki.com. You got to be able to spell it. R-E-Z-N-I-C-K-I. So, first, before we start, we have some things currently in the news. And we're finding stuff in the news just about every day. It's amazing what we're finding. This is one very recent. Anti-piracy group accused of stealing the photo they used in an anti-piracy ad. And this was from the Business Software Alliance. They did this ad, and they ripped off a picture to use in the ad. That's how common this is.
And just so you know, every story that we're going to mention, none of it is made up. Everything is, I should say, the emes, since we're here, right?
Yeah.
The emes. Every reference we make is to an actual story, an actual event. We'll change names and so on and so forth. But we've had this up, and 2 weeks ago, you may have seen on some of the blogs, I sued Rick Ross and several other rappers for infringing upon my photographer's images they used on an album, on posters, so on and so forth. Rick Ross, the rapper, was involved in a lawsuit against another rapper who he was suing for ripping off his copyright in his music. So that was the hook that the newspapers used. While Rick Ross was suing someone for ripping him off, we were suing Rick Ross for ripping us off.
It's like one of those Russian dolls, you know, where one fits into the other. So the next one is just something I found that I really like. This was on like Craigslist. Photographer wanted in Syracuse. We're a solar company looking for a photographer interested in taking some pictures of some of our recent rooftop projects and installations. We are not offering any pay, but you can use the photos for your portfolio. These are large commercial installations, so you should be able to get some great pictures. If you're interested, please email me, blah, blah, blah. And then somebody else posted right after that saying, solar installation wanted. I'm a photographer looking for a solar company to install a project in my recently acquired home office. I'm not offering any pay, but we'll be happy to let you tell people about the great job you did on your installation. This will be a great commercial grade residential installation.
See, now, you guys laugh. This photographer is actually the exception to the rule. And what the analogy I like to use is at 3 o'clock in the morning, if your toilet is stuffed and you call a plumber and say, hey, listen, can you come out, unstuff my toilet? I am not going to pay anything, but I'm going to tell everybody in the neighborhood, if you do a good job, what a good plumber you are. Is there a plumber in the world who wouldn't hang up the phone on you? But if you called a photographer to do that, the photographer would be there in 10 minutes. Why? Who works for free? Photographers work for free. Your potential clients who may be, whether they're for weddings or advertisements or local business people, they know it. They know their audience. They know you work for free. So why are they going to offer you money if you're going to work for free?
The one I love, and it's happened several times. A photographer contacts Ed and says, I got this client, they give me really great jobs, they haven't paid me for 6 months and they have another big job, what should I do? And we're saying, that's not a client, you know? In this case, it was a little unusual in that instead of sending them an invoice, he was sending them a spreadsheet. Yeah. And that was the reason he wasn't getting paid. It was a well-known company he was working for. But that was another story at another time. Another one in the news that came up recently is Judge Judy sues Connecticut lawyer for using her in his ads without permission.
Now this one I love. We did a big piece on this on the blog. This one I really like because Judge Judy, who, a little known fact about Judge Judy, her husband, Scheinland, was voted year after year as one of the worst judges in the state of New York, every year. But she is still a lawyer. She has a license to practice. She has her show. She is, I think, the highest paid woman in television.
Yep.
And she's making, 30 million, whatever.
More.
Yeah, whatever it is, a year. The one who's infringing upon her show was warned by her people, her lawyers, to stop. The infringer was using her image in his ads during her show. Now, what does the infringer do for a living? He's a lawyer. Now, the first reaction among all of us in the office was, what a moron. Well, it turns out that this lawyer is a high-profile personal injury lawyer who's got billboards and does a lot of advertising. He probably, I don't know, I have no personal connection with the case, but he probably thought this would be great publicity. If she had this is a great case, it's in Connecticut. If she has this case in New York, if I'm her lawyer, in fact, she doesn't even need me, she will own him. This case in New York is worth $1 zillion because he's falsely using her image to make it appear that Judge Judy, who's got this high profile as an attorney, is endorsing him. This is like the ultimate case. This is the case that someone like me dreams about, and you would never, if someone told me at a party that an attorney was doing the infringement, I say, you mixed up the story somehow. It's not possible. And this is one of those stories that is not possible, it's just real.
And it has to do with releases, which brings us to the next case, which is a Queen of Versailles filmmaker, Lauren Greenfield, who's a very well-known photographer who made this documentary, and they were sued by the subjects. But Lauren had a really good, well-written release, and it held up. The case was, go ahead, Ed.
This is also covered in the same blog piece. For now, just to, for the purposes of time, what you need to know about this case and why it's important is, the gist of this case is, you need to have some assurance that an adult who's signing on behalf of a company has authority to sign on behalf of that company, okay? You read the blog piece, and the whole issue was the owner's son, I'm oversimplifying, the owner's son signed a release. And did he have the authority to sign a release? Obviously, a guy who works on the assembly line at Ford can't sign a release for Ford Motor Company to buy General Motors. This was not such an obvious case.
And one of the things we talk about all the time, anybody here shoot weddings? Just out of curiosity?
Oh, we got good stuff for you.
We got good stuff for you on that. But the one thing we always say is that the bride or the groom can't sign off for anybody else in the wedding party. Every person has to sign off for it.
You all right?
So,
oxygen.
Yeah, I heard the exact opposite.
Wrong. We'll get
No.
to it.
Wow.
yeah, we'll get to that.
Don't
No,
get nervous
one
yet.
adult can't sign off for another adult. Everybody's got to sign off. But there's some exceptions, especially here in New York State. This was just in the news yesterday. Northeast Ohio model sues Columbus photographer, accuses him of sending her images viral.
Okay. Let me just pick up. This case is about a woman whose image was used and apparently sold or licensed by the photographer to various sex sites, including Playboy. I've had a lot of these type cases. I will caution all of you, I've read this article, I have not seen the court papers yet. This article is without question missing a lot of facts. Having had lots of my cases in the press, I will tell you the press is always wrong. First reports are always wrong. Any of you who have ever been in a war or read reports from a war, first reports are always wrong. There's a lot missing from this story. She supposedly signed a release, but they had some oral back and forth. When you do read about this case, the one thing you take away from this case and all the cases is that clean, simple, one-page paperwork, no problems. All these problems are caused by people who don't have a simple form and sign it and keep a copy. It's because of who said what to whom, when, and where. And when you get who said what to whom and where, when and where, that means lawyers are going to make a lot of money.
And releases are specific to each state. In New York State, it has to be a signed release. So anything you say at all doesn't matter. Doesn't matter what you say verbally. It has to be in writing. By the way, also on this, because I circled it, the woman's name is Nicole Forney, and the photographer is Joshua Resnick. And I just want to say, no relationship to me whatsoever. Just happens to have a similar name, not the same name. But we go over this time and time again. Her lawyer claims that she was fully clothed and they sold this to various sex sites. If you are shooting somebody that is in a provocative manner or nude, or you're going to license it for medicine, for depression or anything like that, the release should be very specific and state that's what you're going to use it for. If you think that a universal release will be okay in those types of instances, it may not be. In fact, very likely it won't be.
We'll get to that also with the Getty, with the AIDS case. But think of it this way: an adult can agree to be in a movie and portray a murderer, a serial killer, a pedophile, whatever. And when the actor signs that contract, he says, "I'm going to be portraying a pedophile," and that's fine. An adult can never agree to have their child portrayed as a sex worker or as a drug addict, or as in one of my cases, a methamphetamine addict, where a company portrayed a 7-year-old as a methamphetamine addict and the older female model, who was portrayed as her mother, as a child abuser and drug dealer. Now, the adult could have, she did not in that case, but she could have signed a release that said, it's okay with me to be portrayed as a drug dealer because I'm getting paid enough money.
But she signed a regular release?
No, yes, she signed a release.
Just a regular general release.
She signed a general release that was better than what most people use, because it says, you can't defame me, you can't libel me, etc. The child's mother was a photographer who happened to be a client of mine, which was wonderful because she used a release from me so that when they portrayed her child as a drug addict, you know, case over at that point. But the key is, if anybody's going to be portrayed, and we'll get to the AIDS case in a minute, in anything that is remotely close to objectionable or sexual, put it in the release. It says, I am aware I am going to be portrayed in lingerie. I may appear semi-nude. I may appear as a victim of, as Jack says, depression.
Here's another case that's been in the news a lot, and we've talked about a lot. You can read a lot of things that we've written, and the last time we were here, I think we covered this quite a bit.
Yeah.
This is now a case, an ending without a finish. And what we mean by that is that they settled this. It went to various courts. It got kicked back to various other courts. There's been a settlement, and as in many cases like this, when they do a settlement, we have no idea what ended up.
99% of all claims, disputes, aggravation, whatever you want to call them, do not wind up in courtrooms. You don't hear about them. I have handled, in 35 years, thousands of cases. 99%, 98% of confidential settlements. So what you wind up seeing in a newspaper or a magazine is, generally speaking, the exception, not the rule. And in this case, it concerned fair use. And at the end of the day, after the trial court made a great decision for the photographer, which Jack and I agreed that made perfect sense.
Oh, it was wonderful.
The appellate court reversed a lot of it.
But not all of it.
And then the parties settled. If the parties didn't settle, this case would have gone to the United States Supreme Court. And good, bad, or indifferent, everybody would have had some guidelines, better guidelines. So now, because this case is settled confidentially, the issue of fair use, which I don't think we're going to get to today, are we?
No.
We're not going to get to. Fair use, go to our blog, is still a very mushy topic. There's no exact mileage chart where someone says something is fair use, but we bring it up at Headfakes, right?
Yeah,
Okay.
I just want, yeah, Headfakes will cover that. I do want to explain for those few who were not familiar with this case, Richard Prince is an artist who took these pictures by Patrick Carriou. Patrick Carriou lived among these Rasta guys for many, many years, had access, came out with a book called Yes Rasta. Prince did this to the images and sold them in a gallery and sold them in...
How much he sold them for?
It was in excess of $10 million.
This is what he did.
All we ever wanted to know was, who was buying these? That's all we wanted to know. Who was buying these? But it came up in court. I mean, this wasn't made up numbers. They sold for about 10 million. There was another, I think, 5 or 6 million that they traded for, meaning they traded images like this for other works that was worth a lot of money.
So those of you who throw out your children's artwork, next time give it a second thought.
Yeah. But it was an amazing case, and it went on for quite a while. Next, the names have been changed in the following, but all of this is true. Ed this was something that Ed got in his office, but the names are similar stature, let's say. And this is a photographer who said, quote,
Yeah.
I shot Christine Brinkley for Caribbean Life magazine, which is long out of business. There was no paperwork of any kind, no releases, invoices, anything. A t-shirt company now wants to use my shots of Christine Brinkley on a new line of shirts. He continues, since the magazine is out of business, I figure I have nothing to worry about, as I own everything, correct?
Now, if this question came from somebody who was like 18, I'd let it slide. This is someone with more than 15 years experience.
And after he talked to Ed, what
How
came up?
soon after these t-shirts would come out do you think that Christy Brinkley would be suing? Those of you may know the case that I had would involve t-shirts for a well-known model who was not Christy Brinkley. That would take Christy Brinkley, or the Christy Brinkley person in this, about 4 seconds to start a lawsuit, which was a guaranteed winner. The rights that the model gives and the rights that you may give or license are not necessarily the same. They could be. You might agree to license an image for Apple to use on its packaging for 5 years, but the model may only grant Apple the rights for 1 year. So they're not always the same. Here, the photographer has nothing from this super ginormous, is ginormous a word?
It is now.
I use it all the time anyhow. Famous person who is not going to stand by as her face gets marketed on a million different things and see a couple of thousand t-shirts come out and her not get a penny.
And just to realize, because this is the confusing part for photographers, copyright and releases aren't interconnected. They're parallel rights. Just because you have the copyright doesn't give you the right of the releases. And we see in a lot of model releases, I see it says it gives the photographer the right to copyright the image. They really don't have a say in your copyright. You know, that part is extra in a release.
The only exception, and this is the odds of you guys ever coming in contact with this are remote, but I hope it happens to you, is if you're shooting, and the best example I could use for those of us of a certain age, Suzanne Summers is the person really credited with making and getting a piece of the action on the infomercials, on the Thigh Master. She owned that product. She took a piece of that product, and that's why William Shatner eventually took a piece of Priceline. In a situation like that, where she owns the company, she is the company, she takes a piece of everything. The first person to do that was Charlie Chaplin. But during normal, regular business in the next 35 years, your odds of coming into contact with somebody, a model who wants the copyright, is going to be exceptionally rare.
Was Charlie Chaplin one of your clients?
Oh, thank you.
You've been doing this a long time. I don't know. So this is one of Ed's cases.
No, that's not my case. This is
not your case.
No,
Oh,
no,
I'm getting confused. Sorry.
This case.
Right.
Okay. This case we did on the blog. This is an extremely important case for a couple of propositions. Do we have another slide on this one?
Yes.
Okay. Stock agencies have, and if you've read anything we've written, you know that me in particular despise stock agencies. I have spent many years of my life suing. I've been in court 5 times with Corbis, and do not suggest that anybody ever sign with a stock agency, just about ever. So there's my prejudice right there. Stock agencies have always maintained, particularly under New York law, that since they are not the ultimate publisher, since they are licensing it out to B&H to use in their magazine, while they may have the photo that you've submitted, since Getty or Corbis is not the publisher, they don't need a model release because they're not actually publishing it. In this case, Ms. Nolan's a 25-year-old healthy female who is portrayed inaccurately as an AIDS patient.
Yeah, I have the picture, but this, you wanted sections 50 and 51 to come up?
Sections 50 and 51, New York Civil Rights Law. This is probably going to be the only law I'm going to give you right off the bat. These two sections are written in absolutely plain English such that even lawyers can understand it. Section 50 is less than 2 sentences, and it says, if you use someone's picture without picture, portrait, or likeness without their written signed consent for trade or commercial purposes, it shall constitute a misdemeanor. That's a crime. In New York, it's a crime. Section 51, which is longer, is the juicy part. And it says, if you are that person, and you don't have to be a professional model. You could be a regular person, and in some cases, a lay person will recover a lot more money than a professional model. But it says you can sue. And not only can you sue for monies that you would have been paid if you would have agreed to do the job, but you can submit to the jury and the judge and in effect an application for punitive or exemplary damages, saying what they did is so terrible that the jury could award theoretically millions. So in my case, where they portrayed a child and a mother as methamphetamine addicts, a jury could have gone wild if the case was not resolved. If a company, I have another case now that you may have seen against Samsung, which used my client, and it's our position, it's in the court papers, that they knew that they didn't have a release for the way they used it. It will be up to a jury to determine how much my client is entitled to, since, as we allege, Samsung knew they didn't have a release, was told they didn't have a release, and kept using it. So it's spin the wheel time, which as a model or as an attorney for a model is great. As a photographer, you don't want to be on the other end.
So this is the same issue that we've been talking about. This is the way it showed up in the, on the internet, on the New York Post. Model sues after HIV positive ad. She did this, she's had a release on it, and they used it in this context, and so she sued because the release did not say she was going to be portrayed as an HIV positive. This caused her all sorts of anguish and issues, and a lot of explanation to her boyfriend and her parents and everybody else.
And in Getty's position, and we go into a little bit more in the blog, but one of the things that Getty says is, hey, not our problem. We just licensed it out. And the judge said, whoa, 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 not so fast. If the ultimate use was illegal, and you, Getty, in plain English, facilitated it and was part of the deal, you're not off the hook yet. If the jury takes you off the hook, that'll be up to the jury. But I'm not letting you out yet.
Another reason I like to bring this up is that there's a photographer, and you have to be careful about photographers giving legal advice. I mean, I'm very careful. I always run everything past Ed first. But there is a photographer who for years has been saying, oh, don't worry about releases, you're not the final user. And recently I've read something else he's written, and he sort of backed off of that. But this is one of the reasons not to believe things like that. You are responsible, even though you're not the final user, doesn't matter.
Shrinks call this, they call it the commonality of like experience. So while none of you, if you woke up at 3 o'clock in the morning with a wart on your nose with green pus running down, none of you would call another photographer to say, what do I do? You'd call a doctor. But for some reason, photographers, and this is unique to photographers, artists, and illustrators, because you think with one side of the brain, you contact people who have similar backgrounds and similar experiences to you. But you wouldn't call them for dental advice. You wouldn't call them if you had trouble with a bunion. You wouldn't call them if you had trouble with your plumbing. But when it comes to legal stuff, you call these people whose sole qualification is they have a keyboard.
And it happens all the time. The math of infringement, and I've followed this guy's work for a long time. He's a great photographer. I just can't pronounce his name. Lewis P. versus John Wiley and Sons.
This is good because this shows you, like, and if I sound like a quizmaster, this is the basic outline of how a court would determine how much money a photographer could recover when the image is timely registered and someone has willfully infringed it. This is the basic math, okay?
And this case is considered to be a bellwether case for copyright infringement issues in the textbook publishing industry. And what happened was, photographer was awarded $100,000 for exceeding the authorized print run limitation for one photo and $30,000 for printing another photo without permission.
Okay.
So he got $130,000.
These were considered willful infringements, okay? Willful, okay? When the infringement is considered willful, the court's allowed to kick up the money, the amount of money they can award, and it could be up to $150,000. And the factors that the court uses include, drum roll.
Well, this was the second. What happened is Wiley contested the amount of it, saying, one, it shouldn't have been awarded, and even if it was too much, they wanted a reduction. So it went to the Second Circuit Appellate Court, and they upheld it, saying all of this.
Okay. So here's your checklist, okay? First is the infringer's state of mind, which in plain English, I'm going to cut out all the legalese, is did the infringer know or should have known that they did not have a license or the right to use the image? So if you have a newspaper or a television, an entertainment company who is a sophisticated licensor and licensee of intellectual property, which in plain English means they own some of their television shows and they'd sue your butt if you infringed on their television show.
In a second.
They know that they need to get written consent from the photographer. So the judge here is saying, first question, what did the infringer know? And did he or she ignore proper protocol? And when you're dealing with a media company, what protocols do they have in place? Whose job is it to check to see whether they can use an image? The next is the expenses saved and profit earned by the infringer. So if the evidence would be that, well, this shoot would have cost them $50,000 for the photographer and the stylist and so on, and a model would have charged $30,000, that makes the case better than if it's a $500 shoot, because by breaking the law, they've saved themselves tens of thousands of dollars. The revenue lost by the copyright holder. If you have an image that you license a lot, and we're going to show images that get licensed a lot, if this adversely affects the photographer's ability to license it to other people, he or she's lost money because it's out there, it's being spoiled in effect. The deterrent effect on the infringer and third parties. This is very important. If you have a big company and you're suing Nike or you're suing Dell Computers or Apple, a fine or a penalty of $25,000 or $50,000 isn't going to mean a whole heck of a lot. If you're suing Sam's Deli, it's going to have a big effect. So the courts weigh that. What kind of effect is it going to have not only on that company, but on others like it, on other delis or other computer companies?
One of the things I do want to point out too is that while we're talking about what look like big images and things, what we find out is the images that get ripped off the most are average pictures, pictures that you wouldn't look at twice, pictures that aren't anything special. Because if it is a big, huge, glamorous picture, a lot of times people know that they can't rip it off. But who gets ripped off the most? The average person.
The next one is the infringer's cooperation. In all of our lawsuits, before we even start a lawsuit, I send a letter, a very lengthy letter, that says, tell us all the ways that you've used and infringed on this picture, and if you think you had the right to use it, tell us why. Because it is impossible for you guys to know how many times and what nature and extent of the infringements of your photo are. Let me rephrase that. If you go into Home Depot on Main Street on Plainview, Long Island, and see your photograph there, what a lot of photographers do reflexively, and it's exceptionally dumb, is they write a letter or they call up Home Depot and they say, you're using my picture. Well,
or they send an invoice.
Right, never.
Which is the worst thing to do. Because once you send an invoice, you've stated what it's worth and what you're willing to accept without knowing if you're seeing the tip of the iceberg.
So at Home Depot, the odds are really good. It's in more than one store. And if it's in Joe's hardware store and it's a point of purchase ad for Stanley Tools, then it may be in 10,000 hardware stores. So you don't know the nature extent. We do that at the beginning because we make a good faith effort to settle every case because A, we'd like to settle without suing, but if we have to sue, we show the judge, this is the letter we wrote, and in one of our cases, there were 78 separate instances of infringement. Their lawyer, a major electronics company, got up in court and said, there are 2. Now, the judge knows there's 78. The jury's going to know that they disclosed 2, and we found 78. The last one is the conduct and attitude of the parties.
And I have that in red for you.
Many times there are ways to do this which are a little too complicated to get into, but it's the lawyer's job to educate the judge and the jury about this business, because the odds are remote, unless you're in, get a Manhattan jury, where there's a good chance that people on the jury are in the advertising business, entertainment business, whatever. Most judges, most jurors don't know anything about your business at all. They know weddings and bar mitzvahs, photographers, and graduation photographers, and that's about it. Conduct and attitude of the parties. Many, many times a big company will say, sue us. Sue us. You have a case, sue us. Now, best example, most dramatic example. I have sued 50 Cent, I have sued P. Diddy, and I have sued Rick Ross, and I've sued others. Do our clients, and am I physically threatened? Yes. Yes. And their lawyers say, are you sure you want to do this? On the other hand, there are companies that say, hey, look, you want to spend the money? Go right ahead. We dare you, because we know that 99% of all photographers who have a really good infringement case do what?
Settle.
Go away.
No, they don't
They
even
don't even
settle.
settle, they go away.
They
They're
let it go
wimps.
away. It's too much trouble.
99% of all plumbers who are owed money get their money. One way or the other. 99% of all photographers slink away. You don't like, photographers don't like confrontation. You know, warm, fuzzy, artsy, you know, you don't want no conflict, no confrontation, you know, it's not worth it. And then also a lot of photographers like that whole victimization thing where they could say to their buddies, oh yeah, I got screwed. Oh, you think you got screwed? Let me tell you how I got screwed.
Yeah, the worst thing to do is to get online and talk about it in social media, because all of that can be pulled into court. It's all discoverable, as Ed would say.
Not privileged.
Well,
There's a question here.
Copyright lawyers work on consignment.
You mean
like,
contingency?
Contingency.
Sometimes, yes, sometimes. I do. There are some that never do. The attorneys who defend the cases never do, because there's basically no contingency.
So,
But one thing we're going to touch on, we touched on the other. If you've registered your work, you're entitled to get your attorney's fees from the court. And if you're a winner, or what they call the prevailing party, the odds are really, really good. You're getting all or more than all of the attorney's fees you paid.
when we get to about 15 more minutes, I think, which is about halfway, we're going to open the floor to questions, because usually, if you're attending one of these things, you have a story. So we're anxious to hear. So with this licensing history, does it matter?
Yeah, sometimes someone will say, well, you know, yeah, we infringed, but you know, your guy has never made a dime licensing the image. Well, let me give you a dramatic example of one of my clients' photos where it made absolutely no difference. Bill Epridge, who recently passed away, his most famous photo was of Bobby Kennedy dying in the dishwasher's arms after being shot. That photo was licensed maybe 5 times. He owned it with Time Life. It was licensed maybe 5 times in 50 years. If someone had infringed on that image, do you think it would make a dime's worth of difference to a jury that that picture, which was treated almost like a religious icon, where it was rarely used, would matter? No. If you have images, my client Al Wertheimer, who was Elvis Presley's first PR photographer, wink wink, lost, wink wink, photographs for 40 years that he discovered in 1996 that he had taken in 1956. He brought those out. We did a TV special. He did a book, et cetera, et cetera. Now, none of those pictures had been licensed for 40 years. Did that mean the day before they came out in 1996 that they were worthless? On the other hand, we're going to get to a photo here, one of my cases, the Bo Jackson photo, which was part of one of the biggest advertising campaigns in history. So the value of the photo is obvious because it sold millions and millions of dollars worth of Nike products.
Well, we're still on this case, the Louis P. case. This is something else the court said. Although revenue lost is one factor to consider, we have not held that there must be a direct correlation between statutory damages and actual damages, which is basically what you've been talking
Right.
about.
So basically means that even if it was a shot you would have done, and you would have charged them $1,000, you still theoretically could recover $150,000 if what they did is that terrible, in plain English.
The court is not stupid, which is something I think a lot of people assume, or, oh, I'll get this by somebody. The people in court are actually pretty
Copyright
smart.
cases are only heard in federal court. Only federal court. No other court. Only federal court. Federal court judges are by and large either really smart, and if they're not, they all have big staffs of very, very experienced and very bright law students and law clerks. So I was in front of a judge who did not know who Tupac Shakur was. His law clerks informed him who Tupac Shakur was and took care of the situation. So if you're in a local court, on other cases, you may get a moron for a judge. In federal court, you're not getting a moron, and copyright cases are only in federal courts.
I loved it when I had to sue somebody for infringement, that Ed was the lawyer on it. The other side said, well, you're not going to make a federal case out of this, are you? And the fact was, yes, we are, because that's copyright infringement. It's a federal case. So the point of a lot of this, and what we keep trying to emphasize in a lot of our talks, and if you heard us last time, your paperwork should be as good as your photography. And that's really critical. A lot of photographers just let that slide. A little bit of prevention up front is going to cause you a lot of less stress and anguish later on issues that you just can't imagine, that are going to blindside you.
Here's the good news on that. If your paperwork is really good and you're calling a lawyer, it's usually because you're about to come into some money. If your paperwork sucks and you have a problem because you didn't get a model release, then you're afraid to call the lawyer because you know the lawyer's probably going to tell you bad news and nobody wants to hear bad news. Here's
a case that's going on now that we can only talk limited about for certain reasons. It's not Ed's case. We've both talked to the person involved in this. Walmart suing a photographer's widow. Walton say they own the copyright to his photos. He's long since passed away. His photos of their family, of the Walton family. He was the Walton family photographer for many, many years. And Walmart is now going to him saying all the pictures and negatives and everything else you have are ours, and we want them. And they're suing on it.
Now, all I'm at liberty to say about this case, and when you read it, is that had anybody used basic paperwork, same kind of paperwork that your local garage uses when you have your brakes adjusted for 49 bucks, none of this would have happened. All this aggravation, all the legal fees, none of it would have happened if they used about, I don't know, 4 pieces of paper.
Yeah. And it's unfortunate. And a lot of things that is being written about it, I can tell you, as Ed said, you can't believe everything you read. I'm reading some stuff now, and it's making me cringe a little bit because you think that they're getting a lot of support where they're actually not. It's going to be interesting to see because Walmart can just outspend, unfortunately, this person. And we'll see what happens. This is something we get a lot from people from the other side. When they ask you to sign their paperwork, and they say it's standard or it's our policy. And that's something that people will use to distract you, to make you think that, oh, this is just standard, it's policy, so we'll sign our rights away on it. Don't ever believe that. Nothing is ever standard. I've gone through so many different contracts on things. I just went through one with a major company I don't want to talk about on something I'm doing. And their lawyers were very nice, but they gave me their standard contract, and I didn't like it. And there were a couple issues. One was intellectual property issues, and the other was indemnification. And their lawyers were very nice. It was very reasonable. I kept asking for different things. They kept changing it. They kept trying to get as much as they could for their side.
And they knew who he was. And they know that he lectures on this. And they know that he's written on this. And they're still trying to.
And it wasn't adversarial. It was just, you know, we're going to ask for the world. And if you sign it, great. If you don't, okay, we'll adjust it for you. And then they adjusted. Well, I still didn't like the adjustment. So they adjusted it again until we finally got to the point where I was happy and they were happy. We both got what we wanted. But their beginning position was, this is our standard policy.
Now the meta talk for that, or the interpretation from English, from the English, you and I are negotiating and you say you want something and I say, no, I can't change that, it's standard. What am I saying to you?
Can't change it.
No, I'm saying shut up, I don't want to talk about it. When I tell you it's standard, I know you're going to shut up, because if you're told that something is standard, you in your mind, like most consumers and most people, say, oh, it's standard, they're not going to change it for me. Yes, they are. If they want to hire you, yeah, they'll change it. Yeah.
One of the things I always get a little bit different than this other one is not in a contract, but I'm working for somebody and they say, well, it's standard for us to pay in 90 days. And as a photographer, my cash flow is very important. I've always been very good on my cash flow and knowing where my money was. And I said, oh, your policy is 90 days? No problem. My policy is 30 days net, 1.5% per 30 days. So if you want to spend 90 days to pay me, no problem, but there will be an interest penalty every 30 days. I got paid in 30 days.
It's in our book. If you can still get a copy, you can still get copies of a book which is sold out. It'll be in the new book. We've written about it. You must have that finance charge in your invoice of 1.5% or 2% per month, depending on what state you live in. That adds up to a lot of money. You don't get that interest if you have to sue unless it's on your invoice, but it serves the function of making your clients pay you on time, because 1.5% or 2% per month is more than credit card interest. It's a lot.
So when I teach one of my business classes at SVA, which I teach to graduate students, I ask, usually Main Street America, any small town America, what's the biggest building on Main Street? Other than Walmart now, I have to now include that. Other than Walmart, what's the biggest building on Main Street? The most ornate? The bank. Do they sell anything? Do they make anything? All they do is they charge a little bit of interest on money they lend out, and they give you less interest on money you let them hold. That interest does add up. It is big money and people don't realize it. And generally when I do put that in my contract, it's just because it gooses them to pay me. You know, if I have to send a statement after 30 days, and we send it at 35 days, with 1.5% added on, what they're going to do is they're going to pay me real quick on that first 30 days without the 1.5%. I'm happy.
Another way to think of it is, if you have money, if you're flush that month, you want to pay off your credit card bills if you have the money to do it and you don't need it for anything else. Those are one of the first things you want to get rid of because of the finance charges. Well, your clients are thinking the same way. It's not any different.
So we go on. You wanted this. They can run, but they can't hide.
All right, another case on the blog is my case. You have the Noble picture later, right? Oh, here's the picture.
No, here
okay.
it is now.
All right. This is the picture of Bo Jackson that was used in the Nike ad taken by Richard Noble, and which we've sued more than a few times on.
And this was the Nike Bo Knows ad. This really started a
This
lot of their
branded the
campaigns.
company. This created Nike. This made the Michael Jordan ads possible, so on and so forth. We sued various people for using this image, including 12 companies that make T-shirts. Now, why am I bringing this up here? Because none of those 12 companies have hard addresses. None of them have quote-unquote real people behind them. They were selling on eBay, on Amazon, and other places. So, lawyers who are not experienced in litigation will tell you, well, you know, if you can't find them, they don't have any money, you don't know where they are, they don't have a brick and mortar establishment. By the way, I have an internet company that sells bricks and mortars. So we got an order from the court permitting us to serve all these companies at their email addresses, or in effect through eBay or their selling platforms, because they were selling shirts with that photograph on them all over the United States and Canada. And a lot of these companies, you'll notice, if you ever have the misfortune to have to deal with them, are located in Michigan or just north of Buffalo, and they run them in Canada because it dissuades people who have been ripped off from suing them, because they go to their local attorney, and the local attorney says, well, I'm not going to chase this name on the internet in Canada. You can. You can. And if this is above your attorney's head, go to another attorney.
Yeah, this is where you see on TV where the process server wants to give you the piece of paper and the person runs away. They're not served. What the court basically says, you email it to them, they're served.
Makes good TV.
They can't run.
If those kinds of things make good TV. If you make the effort, for example, with these rappers, they're surrounded by security all the time. So we served Puff Daddy by having two of us celebrity photographers who he knew serve him right in front of the courthouse with pictures appearing of him getting served in the Post and the News. So if we were unsuccessful, he's got a record company, he's got agents, he's got lawyers. There are many ways to serve somebody. You don't have to stick a piece of paper on them like you see on TV.
And just to show you, it doesn't have to be a fancy picture. We use this picture a lot by Ken Knight.
Anybody know who this is? Who?
Britney Spears' husband.
That's right. For 55 hours.
If you didn't hear it, she said Britney Spears' husband for 55 hours.
55 hours. This.
Because you've heard us speak before.
Oh,
We knew that.
cheating. These are pictures taken by Ken Knight in his studio in Louisiana. These were wallet-sized photos taken of this kid for his family. And as you can see, and Ken will be the first to tell you, it's an utterly average nothing shot. This picture became extremely valuable when Britney married him in Las Vegas and sold the exclusive rights to the Star. So you had Getty and Corbis and various news agencies with no pictures. So what they did was they found his grandma who had that picture on the counter, and a photographer photographed the photograph, and then it was released to about 4 dozen companies who we wound up suing. On the back of the photograph, Ken had a rubber stamp, which is always a good idea, that says, "Copyright Ken Knight, no reproduction or copying is permitted without consent of photographer." So this was a nothing picture that turned into a very, very valuable picture because this kid happens to marry Britney Spears. Who would have known?
And also along the same vein, this one we like too, the Rogers Photo Archives.
Now, anybody know this company? I had never heard of them. Had you heard of?
I never heard of them either, but that
Nobody I
doesn't
know
matter.
has ever heard of them until
We read this. Photo Archive raking in $120,000 per week selling old newspaper photos on eBay. And we're seeing a lot of these. You can see the 2 pictures here. Here's a couple more. What they did is they just got a whole bunch of these images of just standard business shots, headshots of people. And there's so many ads now that I see where it's like people endorsing things and they're stock images of people.
Yeah, this is not reportage. This isn't photographs of the mayor getting assassinated.
And continuing on that theme, a single image taken at a wedding or event may exceed in value the entire fee you receive for shooting that event.
Each one you're going to see now is real. Real.
This is real life from Ed's files and other places. A guest at the wedding is a fugitive who had starred on America's Most Wanted.
And the FBI came to my client, and my client called me and said, obviously this has got value. I don't want to just give it. I mean, I want to help him, but I want to get paid. And he got paid.
And in those cases, you should contact a lawyer because, yes, you do have to hand the picture in, but you want to make sure that the paperwork and everything is correct, or that image could be shown everywhere.
They're happy. Any of you remember Lisa Steinberg? No. Okay. Lisa Steinberg was a child who was murdered in 1987. My client took pictures of her 9 days before she was killed rather. And because of his photos, and we've written and lectured about this a lot, the stepfather was convicted thanks to the pictures. Those photographs were infringed many times, and after Stewart, who took the photos, passed away, his kids basically went to college on the money we recovered on the infringements of those photos. Point is, the district attorneys needed those photos to prove the case. They were wonderful. They were terrific. They were cooperative with us until most recently 24 years after the 20 some odd years after the killing, after the murder. We still licensed them, and we had an arrangement with the district attorney, and Stewart testified and put this guy away, and the pictures put him in prison. But he got paid for using the pictures.
So there's certain pictures that if you get, you should call a lawyer right away. One that I know of too is that there was somebody who filmed with his little phone video, the plane landing on the Hudson. And instead of, well, you know more about that than I do.
Crooms. Yeah.
But what he did was, instead of just giving it to the news agencies and say, oh, use it and you can use my name, for credit, he licensed it and made big bucks on that. But he contacted a lawyer rather than trying to deal with it himself. He knew he had something valuable. Anyway, continuing on this.
These are all weddings now.
A bride who shortly after the blessed event shoved her husband off a cliff.
In the papers, Google it, look it up.
Yeah,
Yep.
Very recent. This was, I got that twice. Another one. Come on. A stunning school teacher. Oops.
Go back to start.
stunning schoolteacher, bride, who within months of the ceremony was arrested and eventually convicted for having sex with her underage student.
Now the backstory of this one's great because the woman was a stunner, and it was a very, very high-end, high society type wedding, and so the husband was a pillar of the community. And just to show you the lasting value of a shot like this, the wedding photographer, by the way, was afraid that this was going to destroy him. He didn't want these images used at all because he knew he would not get other society weddings if the word got out within this, you know, society setting and so forth. And just this week on what website? Somebody sent it to me. The 50 teachers who have had sex with their students. Okay, one of these filler things on one of the websites.
Like BuzzFeed or something.
There's the picture again because she's rated number 3 or whatever, and there's that wedding picture again from years ago popping up out of nowhere.
So you're taking events and you don't know what's going to happen later on. The point was these things suddenly became a lot more valuable than you would think because things happen. Here's
and
another
more than
one.
the photographer got paid to do the wedding.
This is a good one too. You want to talk about this one? Certain wedding photos purchased by attendee of the wedding to assure that they would remain unseen by the spouse.
The granddaughter of a very, very, very famous mob figure who has been portrayed in the movies many times was an attorney who worked in my office, and she had a relative with this problem. And this relative paid the wedding photographer a substantial amount of money just to make sure that the photos of just him with his guma at the wedding did not see the light of day. If you shoot weddings or any kind of social events, you want to get paid ideally for everything up front, way before you have to deliver or transmit any images. If you don't, you will get screwed. Because once they have the pictures that you shot, you have no bargaining power. So these are real life excuses giving to wedding. I did not have to make a single one of these up, okay? So you may have heard some of these, okay? And by the way, most of these came from people with money because people who don't have money don't make these kinds of excuses. They just say, I'm short this week, can I give you $50 and give you $100 next week, $200? That's what people who don't have money who are honest do. I'm broke, okay?
Well, let me give you the scenario too on these. You're done, you're ready to hand over the pictures of the wedding, and it says in your contract they have to pay you before that point. So you're about to hand it over, but they don't have the check. They don't have the money. And this is a bunch of stuff you hear. The first 3 are all related. You know, where do you think I'm going? I'm not leaving town.
Especially if you shoot in a small town or even a suburb or, you know, Upper Westchester, Rockland County. Where am I going? Where do you need the money? Where am I? You know where I live.
And you'll constantly be chasing that person for the next God knows how long. This one we like too. You know me for 30 years. Would I screw you?
If he's saying it, it means he's going to do it. The good thing is you said it, I didn't, but that's, you know.
I've known you since you were in diapers. And what does that prove? He's known you for a long time. The next one is one of our favorites when we always hear this one. And again, these are all verbatim. Did you forget that I was in Nam with your father?
That's my favorite. That's my favorite because I made the guy repeat it to me on the phone because I didn't believe the client. So he was in Vietnam with his father, and that means he should screw Dad's kid who just shot the wedding out of the money that he agreed to pay him. Okay.
Have I ever beaten you out of a dime in my life? The problem with this is you're talking about a lot more than a dime.
Yeah. And usually talking to a person that you don't really do business with because unless he's a serial divorce or marriage candidate, the odds are you're only going to do one job for this person.
I don't know. Repeat business is pretty good in the wedding industry.
That's true.
And the other one, what's the emergency? You went to a bookie?
Yeah. Now, this is a really, really good line. No, I'm serious. This is really good. Because if you say this to a photographer, no, the first thing the photographer says is, oh my God, I look desperate. I don't want him to think that I'm desperate for the rent or anything, or that I have a gambling problem. This is really, really effective. If I was going to use one of these, that's what I would use.
And there's a great video, I wish we had it or could use it, where somebody like goes into a restaurant and they're saying, you know, well, I can't pay you for the full meal today, you know, and it's like, this only happens in our industry. It doesn't happen in other industries. So the other one is,
That's right.
don't you trust me? No, the answer is no. If I trusted you, I wouldn't be asking for
Now,
it.
how you answer, there are no universal ways to answer these questions, because you have to do this within your own personality and in your own business style, knowing your clientele. No one can give you a list of correct answers. The key is to know that this is a tactic. And because it's a tactic, once you know it's a tactic, you don't fall for it. So if someone says, don't you trust me, one response that a person might say is, I want to get paid for the work I did at the price you agreed to on the day that you agreed to pay me, which was today. That's one response. Someone else may have a different response and say, Charlie, my rent is due. The issue is not whether or not I can trust you, it's whether or not I can give a check to my landlord. Or, you want to come home with me and explain to my wife why I can't buy her nice things? You see, it's whatever it is, just perceive it as a tactic and then use your own personality, knowing your own audience.
I can tell you that sitting on PPA for many, many years on the board of directors and hearing a lot of different cases, there were things that always came up. Somebody would do a wedding, they hand in the photos, the people pay for it, they love the photos, they said it looks terrific. About a week later, they don't like the photos. You've had that happen? And you know what it is? They get online and somebody says, you know, if you start complaining and bitching about the pictures that you don't like the quality, they'll give you a reduction in price or they'll give you some of the money back. That's what they're doing, and we've seen it time and time again.
And you know why they do it?
Because it works.
It works.
So we have one more on this one. Oh no, we have a couple more. My goodness, what would your father, mother think if they were alive today to hear you say that to me? They would say, get your money, we know this guy.
This is the confluence of Jewish guilt and Catholic guilt. You know, this is the Catholic guilt that you're going to spend eternity in damnation, and this is the Jewish guilt, like, oh my God, what am I going to do? And then the Jew thinks about 3 weeks what the response is, and the Catholic thinks, oh my God, I'm going to burn in eternal hell. Okay? It's a trick, it's a tactic, it's to get you to think that way.
Is this what they taught you in college?
Yeah, small towns, okay? You're a small town shooter, you go away to college, and gentleman here who lives not far from where I have a house in Pennsylvania, so you have somebody who lives their entire life, you know, 40 minutes outside of Scranton, and they go to Harvard, or they go to Dartmouth, or they go to Duke, and then they come back, and the townies say, this is what they taught you at Harvard? Yeah. This is how they taught you how to treat people?
Mr. Big
boy?
Shot.
Yeah, Big Shot. Yeah.
The next one, you should all know the answer by heart to this one. All the guys should know this one. You do and say everything your wife tells you to do and say?
Yeah.
If you're smart, the answer is yes.
Yeah.
Always say, for the men, always say, I'm going to put you on the phone, you're going to explain this to my wife. Would you like to take the phone, put it in, because if your client is a man, and if he's married or has been married, he is not getting on the phone with your wife. Also, with weddings, we make a big deal about this. The mother of the bride, the typical all-American mother of the bride, and I'm sure you know this, can teach the U.S. State Department and any lawyer you can pick how to negotiate. Mothers of the bride are the best negotiators in the world.
They clip coupons.
You're lucky if you keep your underwear. So don't ever assume that just because mom is a stay-at-home mom with 4 kids who's, you know, not a lawyer or has never been in a job outside of the home, that she will not negotiate. She's negotiated her husband out of everything. She negotiates with her kids every day, and there's nothing you can do that she hasn't seen before.
And she's going to present you with some cookies just to make it nice and easy because she's so sweet. And then you're going to stand there going, what the heck happened
Anybody
to me?
ever work as an auto mechanic? Anybody listen to Click and Clack, Car Talk?
Yeah.
What do you do? And I worked as a mechanic, as a car mechanic. What do you do when you bring your car to a mechanic? Always, always. Bring muffins, donuts, cookies. You bring your car in, you bring donuts, you give it to the guys, your car gets fixed first. Always, all the time.
I'm going to skip ahead to something, and then we'll finish up with some questions. But this is one of the more popular things we've ever had on our blog. It's called Head Fakes and Other Lawyer Tactics. It's sort of going into another direction. And what this is, and you have to understand, because somebody online, of course, on the internet, did not understand this whatsoever, is Ed has to go to maintain his license. He has to go to seminars and other educational things, as all lawyers have to do. This particular class that he went to was a lawyer was telling all the other lawyers what to do and say if your client infringes somebody's copyright.
So remember, if you take 100 intellectual property lawyers, 98, 99 of them are on salary to publishers, entertainment companies. They don't generally represent photographers, illustrators, and artists. It's a lot easier to make a living representing, or working for a corporation. So this is what the guys on the other side say to you because they work.
So if you want to see more of these, all of these, again, it's on our blog, thecopyrightzone.com. So the following is just a snapshot of some of these. First, utilize the term fair use. They make it abundantly clear that the defense rarely is applicable, but should be claimed anyhow, even if there is a slight chance of success.
Now,
this is known as throw everything up against the wall and see what sticks. If this sticks, good.
This refers back to that Prince Carew case, and rather than getting into what constitutes and doesn't fair use, suffice for now to say, if a lawyer or a client says this to a photographer, it sounds very authoritative, and it shuts photographers up. It sounds very, very definitive. The photographer generally doesn't know what fair use is, and this does the trick of making the photographer go away. It's very effective.
The other one is send a letter saying, hey, we've taken it down. Thanks for letting us know, because we take copyright very seriously, and good night. Never offer real money to non-represented claimant. Few photographers, and this is true, few photographers hire lawyers.
They know if they get a letter from a photographer that the odds, literally the odds are less than 1% that the photographer is ever going to hire a lawyer and sue them. So they ignore you. Because statistically and financially, it makes sense to ignore you. And if you then hire a lawyer and the lawyer sends a letter, then you'll get a response.
Photographers send in lawyers thinking that you can make the other party feel guilty. They're never going to feel guilty, trust me. Money's involved. Insist on being provided with a copy of the stamped copyright registration and do nothing regarding possible settlement until or unless you actually receive a copy, because few artists register and even fewer register after the infringement.
I do not represent people unless at least I have the registration pending, at least. They don't have to take you seriously if you haven't registered your work, because you can't sue for copyright infringement unless the work is registered. It's the key to the courthouse. Regardless of when you register, regardless of when you took the shot, if you don't have that piece of paper, you cannot sue. The other attorneys know that. They learn it in law school. Most attorneys have double-digit IQs. Even with double-digit IQs, they know that.
The most popular thing in our book, which is now out of print, and again, we're going to have a new book coming out either at the end of the year or beginning of next year from Focal Press. The most popular part of it is we do step-by-step, screen-by-screen, how to register your work. We can never emphasize enough how important that is.
Yeah, let's do it again. How many people here register all their work on an ongoing basis? Okay? 1, 2, 3. Okay?
I'm 4.
And how many people in the room, right? So that's 70, 60, 70 people. So that's about 4 or 5%. We generally run would you say 2%?
Yeah.
About 2%. Okay? So if I'm an attorney and I work for ABC or the New York Times or Fox or CNN, and I'm in this class, here's more proof. 3 of you. And you're people motivated enough to come to a seminar about this, and still only 3 of you register your work. So those of you who go to casinos or racetracks, the odds look pretty good, don't they?
This one, go ahead.
Well, what's the benefit then should people buy the copyright?
It's a whole issue we're not going to get into because you should listen to our other thing.
What was the question?
Why should you bother about copywriting? You
Oh.
own the copyright from the moment you take the picture, the moment you snap the shutter, the moment you put pen to paper, the moment you put paint to canvas. You, as the artist, own the copyright. That's something relatively recent from the 70s. But without registration, the copyright is, well, I say, worth a bucket of spit.
You can't sue unless it's registered, number one. Number two, if you register in a timely fashion, you can get a lot of money. You could.
It's just the law of the land. That's all we can tell you. We wish there were another solution to it. There isn't. You have to have your copyright registered. You do get some benefits, and there are some cases where if you didn't register it, you're still okay, and you can register after the fact sometimes.
If you go to the blog, look up Andrew Paul Leonard, who's my client. I didn't represent him in that particular case. I represent him in other cases. Mr. Leonard got a decision from a jury for $1.6 million for some photographs because they were registered. They're not of celebrities. They're of stem cells. $1.6 million. Would that make a difference in your life? I know it would make a difference in my wife's life. That's why you register.
Your client, and I love this, your client can always say public domain because they saw it on the internet. An attorney can't unless he or she has ascertained that the image is truly in public domain. So what they're doing is they're saying, telling the client to go out there and do this.
You lie, because I, as the attorney, don't want to look like a putz to the other lawyer, because the other lawyer, if he knows anything, is going to know I'm a jerk. But you, since you're not a lawyer, you say public domain. And this is commonly linked with the most common excuse I get, which is, did you know your client's image is all over Google Images? To which I say, yeah, that's why I've sued 70 people and settled 60 cases, and yes. And you're number 71.
And they think, well, it's on Google Images, so it must be free.
Right.
It's not. Always claim that since there was no copyright notice on your client, who is not a lawyer, had, quote, no reason to know that anything was wrong, and that, quote, no malice was intended.
Now, does this make sense to anybody?
Well, this is since, as you like to say, since Carter was in office,
That's
you've
right.
not had to have a copyright notice on your image to be protected.
This is the equivalent of walking out of Walmart, seeing a brand new Mustang with the keys in the ignition and driving off with the car because you didn't see the name of the owner. It's moronic. It's used all the time. It is totally illogical. If the person did not claim to have created the image, it means they stole it from somebody. If I didn't buy the Mustang, it means either somebody lent it to me, or I leased it from Hertz, or I bought it, or I stole it. That's it.
I like this one. Run a risk assessment. What's it going to cost if we lose?
Yeah.
Excuse me. And this is, we like this because what they're saying is, yeah, we're going to do this. We know we're in the wrong. We may have to pay. But you know what? We might have to pay photographers. We're going to save more by not paying the license for all these images. So if we rip off 100 and we got to pay for 1 or 2, it may be worth our while.
Yeah.
That's exactly what they're saying.
This is also So Sue Us, which I've had in model cases where a major electronics company just says to the model, you know what? Sue us, go hire a lawyer and sue us. And which they readily admitted to. We had a case against Callaway Golf Clubs years ago where they lost a lot of my client's images, and they told my client, sue us. When he told the judge that that's what they told him, the case was over. The judge, as soon as the judge heard that, I didn't have to do anything else, client didn't have to do anything else. That's all she had to hear.
Now, these are excuses we hear from infringers. I'm going to go through this one really quick, and then we'll see if there's time for a question or two, because we're down to our last 7 minutes. Excuses we hear. This is the first thing when Ed contacts somebody who's infringed, the very first thing they always seem to say. We are glad you've brought this to our attention. We take matters regarding intellectual property very seriously. What they're saying is, we take our intellectual property very seriously, not yours, because we ripped you off. And again, the excuses are, and I'm going to go through these real quick, there was no copyright sign or photographer's credit on the image. It's not necessary.
It's better if there is, because it just helps your lawyer show that they knew somebody else owned it, but you don't need it.
This one I like, we're a small business. It's mom and pop operation. I sued somebody for infringement. We've talked about this case a lot. It was an internet company, discountcoffee.com, because I didn't have to sign a non-disclosure. They said, the first lawyer, because they had to get a real lawyer after him, said, hey, it's a small business, it's mom and pop. Ed deposed them and found out mom and pop made close to $1 million a year.
No inventory working out of their house, no employees paying no rent. And I said to the other attorney, do you realize that mom and pop make more money than you and me combined? And there's no such thing as a mom and pop business. There's no such thing as a small business. Would anybody say that a one-person business who has one employee, who's an 18-year-old college girl, who takes and makes appointments for this gentleman, who happens to be a pediatric neurologist specializing in brain surgery, who grosses $5 million a year, is he a small business? It's a one-man operation. There's no such thing as mom and pop. The copyright law doesn't distinguish. It doesn't say, here's the law for Samsung, Apple, and Chevrolet, and here's the law for Bernie's Hardware. Okay? The case may be different, but you're not looking at their tax returns, and whether they made money by stealing your photographs is not your problem. They're saying to you, yeah, we stole your stuff, but we still didn't make any money, so what do you want from us? Does this make sense?
Ed actually had this in court where somebody, Ed and the judge both said, there is no small business exception.
No small business exception.
So we really got to go through these quick. I haven't made a profit in X number of years. Doesn't matter if they made a profit or not.
Anybody know who Corbis is? Didn't turn a profit for 16 years. Did not make a profit. It's intentional. Some businesses are run not to make a profit. You don't want it to run to make a profit. Who cares? Has nothing to do with anything.
Don't talk a lot about this one, Ed. If you sue, we will file for bankruptcy protection. Ed loves this because
want them to.
It doesn't matter. As Ed likes to say, we'll pay to get you down to the courthouse to file. We'll pay for the cab to take you down there.
Copyright infringement cannot be discharged by a bankruptcy court. The bankruptcy judge sends you down the hall. You, in effect, and when other lawyers hear me say this, they'll cringe, but you, in effect, go to the head of the list. Because a bankruptcy judge cannot wipe out a copyright infringement case. He can wipe out a $10 million lease. But if you have a case that they used your registered image, the bankruptcy judge can't do a thing, and will typically say to the bankrupt company, pay him, and then we'll continue on with your other claims.
The picture, we went over this, the picture's on Google Images, everybody's using it, public domain, nope. Thank goodness you contacted us. we always like that one. It's slick. It says, you know, gee, we're so thankful you called us.
It's what stock agencies traditionally did. They would license images out from photographers who had long since left them or had retired or they had died, and they would, you know, wink, wink, not send them a check, and then the photographer would find out about it, or the photographer's spouse 3, 4, 5 years later, and the stock agency lying through their teeth would say, oh, thank God you called. We've been holding this check for you forever. Yeah. We'll get it to you tomorrow. And then what most stock agents did, and one admitted it in a deposition, she owed this photographer $5,000. She sent him a check for $2,500. And I said to her, a very famous person, at the deposition, I said, and you sent him $2,500 knowing you owed him $5, right? She says, right. And I said, you did it because you knew you'd shut him up. She says, that's right. She was an opponent. No one's referred more cases to me than her.
I'm going to skip a bunch of them because we just don't have the time to get to the two that I really like. Like, your client is going to sue over this, and the answer is yes, we will. And
one thing real quick that's important about this, and we're not going to get into how to hire a lawyer, but you want to hire a lawyer who has a record of lawsuits, so that when they send a letter, so when I send a letter, the other side will Google me and see that in New York, I've sued a zillion times. Otherwise, if the lawyer doesn't go to court, the other lawyer says, this guy's not a litigator. He's not taking anybody to court.
We can keep stalling him and pushing it along. And the last one we like is you contact them and said, oh, you know what? We've taken it down. We trust this concludes the matter. And that's the, no, it doesn't. That's the old, you took a knife, you stabbed me in the chest, and when I said, excuse me, you said, oh, pardon me, you took out the knife, and they're now saying, well, now we're even. No, I've been damaged, and the court sees it that way. You took it down, it's fine. In fact, it's better than if you left it up. But even taking it down does not conclude the matter. But that does conclude our talk today. With that,
Thank you.
thank you very much.
Whether you're a hobbyist or a professional, B&H has the answers to your questions. Experience a world of technology at our New York City Superstore. Connect with us online or give us a call. Our staff of experts is happy to help.